So today I'm here with Michael Cortes. I'm going to let you introduce yourself and kind of tell everybody who you are and what you do.
Good morning, Tina. Thanks for having me. As you mentioned, my name is Michael Cortes. I'm a now retired attorney. I was practicing for about 15 years as a second career. Prior to that, I was a stockbroker who went through a horrendous divorce, and I knew
Mm,
there had to be a better way to do things than what I'd gone through. So I figured the best way to do that was from the inside. So I left my career in
mm.
finance and went to law school to do family law, and that's all I've done. My goal is kind of be the attorney that I would have wanted going through that process and to make the process a little bit easier for folks as they go through. I've since transitioned to just mediating to kind of have a bit more of a direct impact rather than the litigating side and the heartaches that go with that.
So on that note, what is mediation? So I think a lot of people, they hear the term, they're going through a divorce, the lawyer maybe mentions it, they see it online, they don't really know what does that even mean. So let's start there.
So it's a voluntary slash mandatory process, if that makes any sense.
Okay.
For well,
So let's
the,
explain that.
the court will generally require people to go to mediation.
Okay.
So it's mandatory in the sense that you have to go generally before you can appear in front of a judge to ask for relief. Relief meaning, I want something temporarily or permanently. Before the judge will order anything, they'll send you to mediation.
Right.
Mediation is an alternative dispute resolution method where people kind of try and work the issues out between themselves.
Mhm.
The key issue is that it's very confidential so that it can't be used against you later in court. The idea that people kind of work things out between themselves, work out an agreement that works best. Because it's better to have people who know their lives resolve their differences than someone in a black robe who knows nothing about them.
Yeah, I think that's an important point too, because I think what people maybe don't know about mediation, you mentioned the confidentiality thing, is that if you offer something to the other person in mediation or you get close to an agreement, but you don't get there, there's no risk to trying because that person can't then go before the judge and say, oh, well, they were going to do this in mediation and now they're not doing it, right? Like that's kind of the idea behind it.
Exactly. They want people to be able to speak freely and throw out offers, knowing that the offer can't be used against them. For example, party offers the other, okay, I'll pay you $1,000 of alimony if you'll do this. Well, they can't go into court later if they don't reach an agreement saying, well, he did offer 1,000 before. None of that can ever come in. The mediator can't be called to testify. The attorneys will basically know to stop if there's attorneys involved to stop the process. Either party can say, nope, that's mediation discussions. It can't be talked about in court.
Right. Yeah, and that's another thing too, that the mediator can't be called in because that's something people have a lot of anxiety over. Like, well, is this person then gonna go in and testify on what we talked about? But the mediator stays neutral, and that's a big part of mediation is to keep the mediator neutral because they can't be called in.
And as part
So,
of that, we talked about it being a semi-voluntary process. It's voluntary in the fact that the mediator has no authority to do anything. They can't make
mhm.
any decisions. They can't place blame. It's really up to the two people who are getting divorced. It's voluntary in the fact that they control what the outcome is, if any. The mediator can't, because a lot of people want to go to mediation and have the mediator decide. Well, mediator doesn't decide anything. They'll offer
Yeah.
options, ideas, but they can't make anybody do anything. They're not there as a judge.
Yeah, I think that's a common misconception. People come in thinking, oh, the mediator is going to hear what I have to say and they're going to make a decision based on that. That's not how it works. You two at the end of the day have to figure it out, or the judge will eventually have to. But the goal with mediation is hopefully with the guidance of the mediator to be able to get to a resolution. Um, so, okay, well, so what's the process look like, right? So people hear about, the term pro se mediation gets thrown around. I think most people hear it, they don't know what that means. So maybe if you can explain pro se mediation versus having attorneys present, kind of what the difference is.
And you kind of alluded to that. The only difference between a pro se mediation and attorney mediation is whether or not there's attorneys present. Um,
Mhm.
Most of my practice is dealing with attorneys setting the
Mhm.
mediation, they're representing their clients. So when you have an attorney mediation, the attorney and their client will be in one room, the other attorney, the other client will be in the other room, and they'll kind of go back and forth. Whereas
Mhm.
pro se is it's just the two of them. So they a lot of times they'll spend the time together in the same room where they can communicate, or we'll break them out as well so you can have individual conversations if there's something they want to disclose as to reasoning for something, but not necessarily disclose it to the other side. Again, it's all protected by confidentiality when you're in separate rooms. So it gives them that ability. But the only difference is the fact that whether or not attorneys are there as part of the process.
Yeah, and I think that's kind of the difference between the type of mediation I do is mostly without attorneys present. It's clients like very early in the process who are trying to work out their parenting plan, have these sort of more high level conversations. How are we even going to separate? How do we start this process? What is the divorce process we want to use? How do we learn how to communicate again? And so it's interesting because mediation is a big umbrella and there's a lot of different types, a lot of different ways to do this, right? There's not one size fits all, I guess.
Well, and 92% of the cases in Central Florida don't even have an attorney involved. A lot of those will have already resolved it without the need for mediation. When they can't reach an agreement and then have to go to, before they can go before a court, have somebody else try to help them reach the agreement. So again, out of that 92%, maybe half already pre-settled. The other 40 something percent will still have to go to mediation without attorneys. So it's still a very common practice.
So you started talking a little bit about some of the misconceptions, right? So what are some of the big misconceptions that you see with mediation? Like people come to you and they're like, oh, this is going to happen. You're like, no, that's not really how it works.
So one of the biggest problems is people have friends, and their friends, as well-meaning as they may be, will give them, quote, advice, which
Yes.
really isn't backed up by the law. They'll come in thinking, well, my friend told me this, my friend got this, and they expect the same result. Well, every family is different, every situation is different. What happens in one case necessarily won't happen in another. There's a lot of very variables. So people come in a lot of times thinking, one, that the mediator is going to make decisions for them and decide things, which they're not, and two, expecting a result that may not be realistic because one of their friends got it under very different circumstances.
A very good point to make. I often tell people, this is part of my coach training. One of the big things they talk about is setting expectations with clients and reminding them that, you have to be very careful of the shadow people in your life, because that's kind of a term that's used in this world, right? The shadow person that's kind of in the background giving all kinds of information and advice that maybe is not really relevant to that person's situation. And sometimes those people can actually steer you into a more high conflict and more difficult situation than you maybe needed to be in. So just being very well aware of who you get your advice from and kind of putting it through that filter is very important, I think.
One of the biggest dangers we see with that is the Facebook groups, Facebook support, divorce support groups, women's groups, men's groups, where they're getting advice from laymen in other states where the laws are extremely different. So
Totally different.
family law is very different from state to state. So you may hear advice that you want to hear from somebody in Arkansas, for example. Well, it doesn't apply here, but then that's what they've got in their mind, and that's what they've hitched their cart to, and they want to follow the Arkansas laws and how things work in Arkansas. Well, it doesn't happen.
Right.
So sometimes break through some of the bad information people have gotten along the way. While certainly well-meaning, doesn't necessarily mean it's accurate.
So what about legal and financial advice? So people come in sometimes to mediation and they're like, well, what should I do? What does the law say? Like, how do I do this? Or, you tell me, like, where's the line, right? Like in mediation.
So the way I look at it is you can give certain legal advice. However, it's got to be even legal advice. It can't be to one benefit or the other. For example, I will a lot of times explain to people how the process goes, what they need to file, that sort of thing. However, I can't tell somebody whether something is a good deal or a bad deal because I can't advocate for one side or the other. Now, I'll give advice to, hey, here's a type of parenting schedule that may work for you guys, given your work schedules, given your holiday, your religious differences. Here's something that might work for both of you, but it could be the same advice to both sides.
Right.
What I can't do is give advice to one side. Okay, well, this is what you should do. He's probably able to do this. As well, she'll probably take this. I can't do that because now we're at the point of advocating.
Right.
Options and so forth, as long as it's very neutral and again even-handed. It's going to be the same quote to both sides. That's
right. Because mediation at its heart, at the core, right, it's like an option building process. It's helping people try to find, okay, this is what I want. This is what I want. And now how do we find an option in between that both people can live with? Maybe we find an option that both people actually do love, right? Rare. Usually it's kind of like that give and take compromise, right? But yeah, at its core, it's an option building. I think the line crossing is when you're like, well, in your case, I would do X, right? That's where now we're crossing that threshold. I think a lot of people need to understand that.
And I can do that to a certain extent, as long as it's the same advice to both of them. For example, I might tell them, hey, for your situation, it might be best if you all do a Christmas schedule like this. And again, type of advice is okay because it's not favoring one or the other.
Right.
It's a little bit different from telling, one party said, hey, this is a great number of alimony, but you can probably get this. That's a different. Now it's biased towards one side and not the other. Sometimes, especially with kids and holidays, a lot of people don't know. It's like, well, they always ask, what's the norm? Well, there is no norm. Every family is different. So it depends on what the family does. Do they travel for spring break? Do they not? Does one families always celebrate Christmas Eve and one always celebrate Christmas Day? Well, if that's the case, maybe it doesn't make sense to split it like a lot of people do. So it's going to be very tailored to the particular families and their particular situation and their kids. And they know their kids better than anyone, and they're going to do a better job of reaching an agreement on those kind of things than a judge will who doesn't know their dynamics.
Yes, on that point, I would say that that is one thing that I think sometimes people have this idea of, oh, I'm going to go have my day in court and I'm going to tell the judge all the things this other person, does wrong, and then I'm going to get everything I want. And what they don't realize is even, let's say a judge says, okay, we're going to do 50-50 time sharing. There's a lot of ways to carve 50-50 time sharing. Okay. A judge, they don't care about your lifestyle. They don't care, like they're not involved in the kids' day-to-day extracurriculars. They don't know your work schedule. They don't know all these little micro details about your life and about what works for your family. They don't know, maybe your child has autism and they don't transition well. And so the judge might not know and understand the intricacies of your family dynamic. And so it's so important to be able to stay in a mediation setting so that you can control, okay, we're not just doing maybe, every 2 days to get to 50-50, but maybe week on, week off is better for us. Or maybe we want more weekdays with one parent during the school year and then more during the summer with the other parent because they're a teacher and they have a more flexible schedule. So, I mean, there's all kinds of things that we can do in mediation that the judge is just not, they don't have the time or the knowledge of your
Right.
family to do it.
One of the biggest instances we see with that for scheduling is a lot of times judge will just do a week on, week off. Well, let's say you've got a parent where they're coaching the child's activities on Tuesdays. Well, maybe that child should be with the parent every day on Tuesdays because the parent's going anyway. So,
Right.
I mean, there's again so many particulars that in each family that has to be dealt with that a court doesn't have the resources or the time, unfortunately, to deal with.
Right.
They want to do what's best for the kids, but a lot of times they just don't have the resources and the time to figure out what that is. And they have a lot of approaches that may or may not work for a family.
No, definitely. So what about, people think that maybe mediation doesn't work unless we already agree on everything, like this isn't going to work, I have to go before a judge, right? What's been your experience with that when you have very, very different perspectives?
Yeah, surprisingly, a lot of them will reach an agreement. They come in thinking there's no way this is going to happen. They're never going to agree on anything. They just want their day in court. They want the other side to be punished by a judge, which never happens. Judges don't care who did what wrong because they hear it all day long.
Right.
By the time we figure out, kind of what can they agree on, what don't they agree on, talk about some different options, a little bit of negotiating, and eventually a lot of times they'll get there. Sometimes they can't. They can agree on some things, they can't agree on maybe others. Usually a lot of people will be able to work out an agreement on the kids as far as time sharing and parenting and holidays, but they can't agree on the financial aspects. They can agree who's going to keep the house, but they can't agree on alimony. Well, it's much better to have a 1 hour trial, for example, on alimony than an 8-hour trial on everything. They're going in there with everything. The judge kind of, their eyes glaze over, they get tired, and maybe they don't pay much attention. If you can resolve what you can to resolve in a much shorter trial, much more attention from the judge's standpoint as far as being able to focus on the outstanding issues, 90% of your case will have been resolved to your satisfaction based on what you've agreed to.
So how would somebody, let's say, two people decide, okay, either with lawyers or without, we're going to go to mediation. This is the right choice for us. Like, how would you prepare to have a successful mediation and come to agreements?
So one of the couple key things is one, know what everybody's income is, what the assets are, what we're fighting over. A lot of times people come in and say, well, I don't know what we're arguing over. Or, well, I don't know how much they make. So, mediation shouldn't be the time to start asking for pay stubs and bank statements to know what they had. Hopefully that was been done ahead of time. I mean, do we do it during mediation? Absolutely, because people come in sometimes unprepared. It costs them more time and unfortunately therefore more cost to go through that process. Secondly, is kind of knowing what it is that they want. A lot of people come in without a plan. They come in not knowing even what they want. It's like, well, I do want the house. Well, I don't know. Okay, well, why not? Are we dealing with child support? What do you propose for time sharing? And they haven't given it any thought. So a big part of it is preparation. Kind of listing out what you have as far as assets and liabilities, maybe who's going to take certain ones, who's going to be responsible for certain things. At least have an idea of what it is that you want. What I have found is a lot of times when people do know what they want, a lot of times they match up. They just haven't, because of the discord or the conflict, they haven't talked about it, but they may actually be on the same page on a lot of things. So sometimes we kind of go through, list out one person's wants, the other person's wants, realize, okay, well, these 5 match up. So let's just get that taken care of. Now let's move on to the things we don't know and go from there.
And then, well, and then you get the positive momentum to start building, and people realize, oh, maybe we're not so far apart after all. Maybe we can find an agreement. And I think that's like the big opportunity in mediation, teaching people how to communicate again after years of probably very dysfunctional communication.
And a lot of times, once people realize that they have everything about 80% settled, they're much more willing to negotiate at that point to get the last 20% done, knowing that they're
Right.
that close.
No, that totally makes sense. Yeah, another thing I always tell clients too is don't just come in with one proposal or position and just be like, this is my position, I'm not backing down, but try to think through, okay, if they don't agree to that, then what might be a second option that I could live with, and maybe even a third option that I could live with, rather than just having your one, hill that you're dying on and that's it. Like, I'm not even going to entertain anything else, because sometimes you may want something ideally, but deep down, there's just no way they're going to agree to it because you know them, your history, and it's just not going to happen. So being realistic, I think, is a big part of it. Is what I try to coach with my clients is be realistic. They're not going to agree to this. So what are some other alternatives that we can try to find a compromise that you can actually live with?
And kind of along those lines, when I was practicing, I would always meet with my clients before mediation. Okay, here's our ideal. Here's
Mhm.
where our goal really is, maybe a little bit below that. And then here's kind of our drop deadline. Okay, here's the absolute minimum willing to accept. To know what that range is going to be before you win. Because a lot of times they come in, they don't know, and they're thinking about it for the first time and trying to process all of that under the stress and pressure. And it doesn't, a lot of times people just kind of walk away from the process. So it's good, whether with or without an attorney, you kind of sit down, okay, here's the goal, here's my objectives, here's what I'm willing to settle for, here's the absolute, no, I'm not doing anything less than this. And then you've
Mhm.
got a range to work with. You kind of start from one point, know what matters, what doesn't.
So what would be then on the flip side, right, some of the blockers to being successful in mediation from your perspective?
One of the biggest ones is, well, two things. One is lack of information. You're talking about not knowing. It's okay, I want half the account. Well, how much was in the account? I don't know. Then having to go back and find statements. Well,
Yeah.
I want this, I want that, but not knowing when necessarily what things are worth or how they pay for it. The other one, sadly, is emotions. I mean, people are in here because they're very upset. They're very angry. They're emotional. That's to be expected. A lot of times people want to focus on what was done in the past. Well, 5 years ago we did this, 4 years ago. And sadly, a lot of that doesn't matter going forward. What they
Right.
did, fares, the spending, whatever it was, is water under the bridge. The court's not going to deal with it, and it's impeding the process now because it's clouding judgment and the ability to move forward. So
Mhm.
I always a lot of times suggest maybe go to counseling during the process as well to try to get their head straight and deal with the past issues so they can
Right.
really in the future, because that's unfortunately what matters. You can't do anything about the past, and
Right.
talking about it and being upset about it doesn't change your outcome for the future. So part of that is what's one of the biggest blockers is the emotional component of being able to move forward.
One of my mediation trainings was with Bill Eddy in the High Conflict Institute, and one of the things he always says is any complaint about the past can be turned into a proposal for the future. And I think that's really that mindset shift of, okay, you didn't take the kids to extracurriculars before, you didn't do this, you didn't do that. And so, okay, well, that didn't work for you. So now how can we reach an agreement for next week and tomorrow and next month that does work for you, rather than focusing on what they did wrong before. So it's like a mindset shift that's very, very hard for people, especially if it, like you said, infidelity, or one parent maybe wasn't around as much and now suddenly they want to be 50-50 time sharing parent and be really involved. And there can be resentment there of like, why weren't you doing that during the marriage? Now suddenly you want to be a part of their lives in that way. There can be a lot of these issues that really can block somebody from being able to agree to something.
And that's a great one because a lot of times you do see that where one parent has been the primary caregiver and so
Mhm.
we'll just keep this all the time. The other person traveled for work, so forth, but that parent still wants to be a parent. And while they may have had certain roles during the marriage, if the marriage is over, everyone's roles are changing. The stay-at-home
Mhm.
mom is now also going to be a breadwinner. The dad who wasn't involved because he worked is now going to, a lot of times wants to be a parent. Just because they've stopped residing in the same home doesn't mean that they have any desire to be less of a parent to their children. And
Right.
that's kind of where a lot of the realistic standpoint, has to come in because a judge is going to say, hey, you want to be a parent, be a parent. If nothing
Right.
else, go up to hang themselves, see if they can do it. A lot of times the dads, it's usually the dads who work a
Mhm.
lot aren't necessarily as involved with the kids. If you give them enough rope to hang themselves, either they can't do it and then they acknowledge that they can't do it and then you move forward, or they do and then now your kid has two active parents in life, which is not a bad thing. generally.
Which is ideal. And then also, by the way, the other parent has more time for themselves and to de-stress and have that sort of bandwidth to work and all of those things. So, and well, now also with the official, presumption in Florida being 50-50, it's sort of like expected that it's that unless one parent doesn't want it.
The courts have been doing that since October of 2010, when they got the presumption against rotating times. The courts have generally been doing 50-50.
Yeah.
They're required by law to do 50-50 unless there's really good reason not to do it. Really good reason would be essentially, drug use, serious felony convictions that would impact the children. There's going to be a very, very, very good reason. So
Right.
more than likely, the courts are going to order a 50-50 type schedule. Now, the question is, what does that 50-50 look like? Is it a 5-3-4-3-3-4, week on, week off? It varies depending on the family, depending on the particulars.
One of the other things too is getting stuck on one small issue and not being able to focus on any other issues. How often does that happen in mediation?
It doesn't happen too often. Occasionally we have the issues. We had one where the issue was the father carried a firearm, he had a concealed weapons permit. The mom didn't want him carrying the firearm when he had the kids. Everything else, the case was resolved. As far as he agreed to lock him up at home, it was whether or not he could carry it on his person during time sharing. Resolved everything. We set a 30-minute hearing on that one issue, let the judge, and then they were done. So even if there's something that people can't agree on, we can carve that out and resolve everything else.
Yeah.
This is the 2-day trial, given the assets and the special needs of the children and so forth. It would have cost them a fortune to actually litigate it, but we were able to resolve everything but that one little issue, which is an important issue to both of them. He was not going to give up his right to carry, and she didn't want the kids around that because of violence issues. Let the court deal with it. They'll resolve everything else.
Well, a lot of parents, I think, obviously everybody going through divorce is worried about how expensive this process is going to be. What are they going to potentially lose during the process, right? It's a lot of fear driven. How would you say from a cost standpoint, right? Litigation versus mediation. If someone's considering, oh, I'm going to go, to court and have my day in court with the judge versus I'm going to try to mediate, like, how does that compare financially?
Yeah. When you do with clients for consultations, they would always ask, how much is it going to cost? And my range over the last 15 years was anywhere between $2,000 and about $350,000. Somewhere in that window. How long does it take? Anywhere from a month to 6 years.
Yeah.
I would generally, for trials, for example, just the cost of going to a trial for a 1-day trial, I would typically charge my clients about $10,000 to $12,000 just for the trial. That doesn't include the $20,000 or $30,000 they may have spent getting there as part of that litigation process. So I've had, the worst I had was a 5-day trial, and that was another $350,000 case. So when I went through my divorce back in 2004, so now 20 years ago, it cost the two of us a little bit over $140,000 to get divorced. And that's when I knew this was the wrong way to do things. We ended up in trial. We ended up with substantial cost and a lot of the emotional turmoil that goes along with it. It's not a quick process. It was a 3-year divorce, and it soured our relationship ever going forward. So,
I mean, I think that it's very hard for parents to recover from litigation, period. And honestly, I think the worst potential option for the kids too, because they're just, deep down, they know that what's going on, especially if they're old enough, and it's just a really tough position for the child to be in.
And even at any age, even the 3-year-old can sense the stress and the tension. They don't even have to cognitively know, they can just feel it. They're very perceptive. People think children don't know. Children know way more than you think. And they also to tell each parent what they want to hear. That's just part of the process. Subsequent to that, I did go through another divorce. We were able to work things out in mediation, got things settled. And I look back now and see the difference in the children and the relationship they have with each, the relationship with the other parent. And the litigation route just damages that relationship forever. Whereas once we were able to settle, we're like best friends. We have keys to each other's house. We communicate really, really well. And our child is so much better because of it. Doesn't require the ongoing issues and the counseling that maybe the first child needed because of all the conflict and animosity.
And imagine too, you talk about hundreds of thousands of dollars, like what could that money have been spent on, right? Like, I mean, investing in the child's future, either obviously college funds or even, buying them their first apartment or helping them with other things. Like there's so many other uses. And even if not for the child, maybe just so the parent could go take a vacation and get a break from the stress of the divorce, right? That could have been a nice way to spend some of that money.
It's why I did that. Being the finance guy, when I went through my divorce, I remember doing the math. I go, okay, well, we separated when he was 5 months old, so almost 6 months. So I said, okay, that same 140,000 at 8% rate of return for 17 and a half years till his 18th birthday would have been $833,000.
Yeah.
That's Harvard, that's medical school, it's a lot of vacations that funds they should have gone to either ourselves or to our child rather than to attorneys.
Hmm.
The way to do that. That's not where you want your money to go. Um,
Right.
Spending $12,000 going to a trial. Well, that's not money you're going to ever feel or get back. Instead, you're paying to fight. That's a
Hmm.
great vacation or a world around the world cruise
Hmm.
rather than spending it on lawyers. So there's better ways to spend it if you can avoid it.
Yeah, there was a lawyer who said that once, you're going to end up paying for my kids' college tuition instead of your own. And isn't that unfortunate how often that happens? And that's the real beauty with mediation. There's a lot of different mediators out there, there's different styles, there's different ways, obviously, with attorneys, without attorneys. And depending on the dynamics of the case, that's going to dictate. There's some people who can't afford to retain a lawyer for, $7,000, $8,000. And so, there's sort of that option to mediate outside of just, you have pro se mediation. That's kind of one step up from just going to court before a judge and kind of hoping for the best without lawyers, right? And then you have mediation, like what you specialize in mostly, which is with attorneys, where you have the best of both worlds because you have your lawyer in the room with you advising you, but you're also in a collaborative space where you're really trying to reach an outcome without this dragging on for months or years and draining your entire life savings. And sometimes, by the way, not even just your life savings, but money you don't even have, going into debt to get divorced. It's like wild.
Well, and it blows my mind because it's a very expensive process. And realistically, it's not anything that anybody wants to do. Nobody ever wants to get divorced. Sometimes it's a necessary evil.
Right.
Kind of liken it to cancer surgery without insurance. It's like no one wants to go through cancer surgery, but it's better than not having the surgery if you have cancer. You've got to get rid of the
Right.
problem. It's a very expensive thing to do, but it's a necessary expense to a certain extent. There are attorneys out there that will do just mediation without doing litigation side so that you can have the advice and the hand holding
Mhm.
without taking on the full expense of full litigation.
Mhm. So, do you work mostly virtually with clients, or how do you mediate at this point?
I will do mediation either in person or virtual. Since COVID, probably 95% of mediations have actually gone virtual. I was
Hmm.
not a fan of the idea at first, but the more we did it, I kind of realized that the success rates were pretty much the same. You're
Yeah.
just resolve it virtually than you are in person. I used to think you needed more in person, be able to have them sign right then and there, but between DocuSign and Zoom, it's gotten to the point where it's just as fruitful either way, honestly.
So then how would people find you if they want to reach out to you and see if they can work together with you?
My website's Cortes Mediation, Cortes, mediation.com. And there's a lot of information as far as the mediation process goes on there. There's also the availability to see my schedule. People can even schedule it right then and there. They have the online scheduling ability, and we'll send the link out. They can tell me whether it's going to be in person, where it's going to be in person, or if it's going to be virtual. And as a lot of the questions as far as the process goes, to be able to make payments online. It's a very simple, try and keep it as simple as possible. Again, having done this for 15 years now, kind of know what works, what doesn't. The typical way of scheduling mediation is a lot of phone calls back and forth between one person's office calling mediator, then calling the other person back and forth and figuring out availability. It's a little bit easier when it's all updated online immediately as to what's available and what's not.
No, that makes a lot of sense. Well, awesome. Thank you so much, Michael. This was really informative. I think people learned a lot today, and it's going to be super helpful. I really appreciate your time
All
and look forward to continuing to work together.
right, it's been a joy, and I'm always here to help out whenever I can. Thanks so much,
All
Tina.
right.